The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in Case 19-863, Niz-Chavez versus Barr. Mr. Zimmer.
Thank you very much, Mr. Chief Justice, and may it please the Court. The statute's text and the changes Congress made in IRIRA unambiguously establish that a notice to appear is a specific notice document. As a textual matter, the government simply cannot explain why Congress used the phrase a notice if what it really meant was simply notice in the abstract. Even more remarkably, though, the government all but concedes that accepting its interpretation means that Congress made significant changes to the statute in IRIRA for no reason at all. Before IRIRA, the statute authorized the very two-step notice process the government defends here. It required an order to show cause, but allowed the government to provide the time and place of the hearing, quote, in the order to show cause or otherwise, end quote. By the time of IRIRA, Congress had good reasons to rethink that two-step notice process. It burdened immigration courts, which were forced to resolve disputes about whether the government properly served the separate hearing notice, and, as this court noted in Pereira, it confused non-citizens by forcing them to piece together information across multiple documents that could be served years apart. So, in IRIRA, Congress created a new form of notice, a notice to appear. Congress largely copied the pre-IRIRA notice provisions, but, crucially for this case, Congress cut the language authorizing the government to provide time and place information in a separate hearing notice and made that information a required part of a notice to appear. The government, however, refused for many years to comply with that change, and to avoid the consequences of that refusal, it now asks this court to read that change out of the statute entirely and deprive Congress's explicit rejection of the two-step notice process of any meaning. This court, however, should give meaning to IRIRA's changes and should hold that a notice to appear, like an order to show cause, is a specific notice document that includes all of the information specified in the statute. That is the only way to make sense of the statute's text and structure, and it is the only way to read the statute that is consistent with IRIRA.
Mr. Zimmer, would the stop time rule be triggered if the alien received the two documents in two different envelopes on the same day?
I mean, yes, Your Honor. Certainly, if it's not in the same document, we don't think it triggers. Sorry, I mean, I guess no is the answer. That if it's in two different documents, it does not trigger the stop time rule. And I think that the point of that is that there's no way to distinguish that situation from the situation like my client's, where he received the notice 2 months later, or the situation in Pereira, where the government tried to serve it a year later, but didn't even serve it correctly, or the situation in Camarillo, where the government served the hearing notice 2 years later. I think what Congress was doing was trying to create a clear, firm rule that required that all of the information be provided together.
Well, I think you're probably right that there's no way to distinguish it, but if it gets to that absurd result that you've got two envelopes and you put them together, you get them on the same day, and it's got all the information that you're entitled to, that's nonetheless not a notice to appear.
Well, Your Honor, I don't think it's absurd in the sense that Congress, that the whole point, what the Congress was trying to solve was that the hypothetical assumes that everything works effectively, and I think that often, as the House report shows, these hearing notices weren't being properly served.
Yeah, I know. I think you're just fighting the hypothetical. It's certainly, if that were what had be done, that they were received at the same day, I doubt that would have attracted Congress's interest. What if they're two separate documents in the same envelope?
Well, I think if it's all provided together, it's effectively the same document. So I think if it's in the same envelope, then it is one document, and it would be a notice to appear. But I think that what Congress was doing here, the problem that Congress was trying to solve was that the problems that were caused when this information was served separately, and so it created this firm rule. And I think that it's very clear from the changes that Congress made in IRIRA that that's what it was doing, and it wasn't distinguishing.
So it's not, but I thought your answer was to the effect that it's not a firm rule. If you have two separate documents, the fact that you get them in the same envelope, it seems to be a functional analysis of whether or not notice has been given as a matter of reality.
Well, I guess our position is that it all has to be provided together, and I think if it's all in the same envelope, it's provided together. I mean, I think that's sort of what the idea of a document is, whether it's on 1 page or 2 pages, I don't think is the question. But if it's all in the same envelope, I mean, it is for all intents and purposes a single document in a way that it's not if it's coming separately. But again, I don't think that what Congress was doing here, this idea, if the government can serve 2 envelopes that arrive on the same day, then surely it can just put all of the information in one document and provide it together. And I think that's clearly what Congress intended that the government do here.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Zimmer, let's go back to 1229A for a second. There is no definition of a notice of appeal, or notice to appear, I'm sorry. The definition is written notice, and it says parenthetically in this section referred to as a notice of appeal, notice to appear. So, and you seem to put quite a bit of weight on a notice to appear. What if that was not there at all? That parenthetical did not appear there.
Right. So I think this would be a very different case, and I think our textual argument would be a much more difficult one. And I think that at that point there probably would be ambiguity in that provision. I still think at that point that the history here, sort of the actions that Congress took in IRIRA and the changes that it made, would still be a compelling reason that we're right. But I think we would have a much harder argument. But of course, this court has repeatedly made clear in cases like Gustafson and Bond that it is appropriate to consider the defined term itself in understanding definitional language, and that's why the phrase "a notice to appear" is particularly important here.
But again, I go back to what the statute says. The statute refers to written notice, and it defines written notice. It does not define the parenthetical. The parenthetical simply says referred to as. It didn't say that what was being defined. So it would seem that you would have to rely on the reference, not the definition.
Right. Well, I think that under the way Pereira described this provision is that you have a defined term, a notice to appear, and then the definition is written notice specifying that information. And again, I think under cases like Gustafson and Bond, when you're trying to understand the definition, I think that the definition, sort of the written notice language that you're talking about, could be read either way. I think that in context, it doesn't explicitly require a specific notice document, but nor does it explicitly authorize the government to use multiple notice documents. And that's why, under this court's precedent, it's necessary to look to other contextual clues, like the defined term itself, like the other statutory provisions that really don't make any sense if you're not talking about a specific notice document, and like the history, and like what Congress actually did in IRIRA. So we're not arguing that absent the parenthetical, the statute would be unambiguous. I think it's unclear, but I think that the defined term and these other statutory provisions and the history of this provision really resolves that ambiguity and makes it clear that what Congress was talking about here was a specific notice document.
Thank you.
Justice Breyer?
Fine. I had the same question as Justice Thomas. If you have anything else you want to say, go ahead.
Well, if I could just sort of emphasize then the historical point, which I think is really the most revealing aspect of why the sort of any ambiguity in 1229A1 really has to be it sort of has to be resolved in our favor, in the sense that the statute used to authorize the government to use multiple, to provide notice over the course of multiple documents. It used to define an order to show cause as notice of specific information that did not include the time and place of the hearing, and then had a separate provision that authorized the government to provide time and place information in the order to show cause or otherwise. And in IRIRA, Congress specifically cut the language authorizing that the government provide a separate hearing notice and required that time and place information be provided as part of the notice to appear itself. And on the government's view, on the government's interpretation of the statute, that significant change to the statute's notice provisions accomplished practically nothing. It didn't change the government's notice requirements at all. and this Court's precedents plainly require that significant changes to the statute be given a real and meaningful effect, and the government's interpretation would deprive it of that. And I think that's really the clearest reason why any ambiguity in the phrase written notice needs to be resolved, is necessarily resolved in favor of requiring a specific notice document, which is, of course, consistent with the defined term itself.
Thank you.
Justice Alito?
What if it turns out that the government has great difficulty at the time when notices to appear are issued in setting an appearance date that will be complied with in most cases? So suppose they put down appearance dates that are like 10% likely to hold up. Would that be sufficient?
Yes, absolutely. I think that as long as there's a date, once the date is put down on the notice, then it becomes the date at which the non-citizen is required to appear.
Well, what if in 95% of the cases that turns out not to be the date?
Yeah, I mean, I still think that I don't think that there's sort of the non-citizen would have an opportunity to sort of, bring some sort of statistical analysis as to whether it's likely to be the date. But I think that there's still a real important purpose served in having a date put on the notice to appear.
Well, was the answer to that yes or no? If it's 95% likely to be changed, is that sufficient, or can that be challenged?
No, I don't think it can be challenged. I think that's sufficient.
What if it's 99% likely not to be the real date?
Yeah, I still think that's sufficient. We're not arguing that there's any kind of if there's a date that's down on the piece of paper that is a date at which the hearing, technically could take place, then the non-citizen is required to appear at that date, and by definition, that is at that point in time the date and time of the hearing. But there's a real.
So can I take you just back to the Chief Justice's question? So, as I understood your answer, if the document that's labeled "Notice to Appear" and another document that sets the appearance date arrive at the same time in two separate envelopes, that's not sufficient. But if they're in the same envelope, that's okay then?
Well, yeah. I mean, yes. I think if the information is provided together in one place, then that's accomplishing exactly what Congress was trying to accomplish by moving the time and place information from an optional part of the order to show cause to a required part of the notice to appear. I think that's exactly what Congress was trying to do, and to avoid these types of disputes about whether the hearing notice was properly served. I'll note, just to get back to your initial hypothetical, that it is really very much a hypothetical in the sense that the government has told this court in its brief that it can comply, and that it is now largely complying with the statute's requirement, and it's providing information about the actual hearing date up front. And that's not surprising. This court addressed this.
If Congress was determined for the alien to get all of this information in one document, why does the statute allow the government to keep changing the actual date of the hearing?
Well, I think it would be. I mean, I think that that's sort of just a necessary function of the fact that there are going to be times when the hearing has to change for a whole host of reasons. And I think it would have been unrealistic to say that, once there's a date put down on the initial notice document, the government doesn't have, that's sort of set in stone and can't be altered. But having.
Counsel, thank you.
Justice Sotomayor?
Counsel, can you explain why the individual information that's required by the statute to be in the notice of appeal, why each piece doesn't have independent value? And by that I mean, what is the damage that you believe Congress was trying to avoid in doing piecemeal notices?
Sure.
The fundamental question that I think some of my colleagues have asked you so far is if each of the pieces of information have independent value, why would Congress have wanted to specify it in one document?
Right. So let me give maybe three answers to that, Justice Sotomayor. I mean, as a big picture matter, if you look at the specific pieces of information that are required, they're all closely related in the sense that they're connected to the information that a non-citizen needs to defend herself against removal charges. You have things like the acts or conduct alleged to be in violation of law, and the charges against the alien and the statutory provisions alleged to have been violated. To start providing the acts or conduct in one document and then a year later to provide the charges and then a year later to provide the hearing obviously makes little sense. And could be incredibly confusing. But to be a bit more specific as to the time and place information itself, I think there were two concerns that were motivating the changes that Congress made in IRIRA. The first one was that Congress was sick of immigration courts having to resolve unnecessary disputes about whether this hearing notice was properly served. And you can see that in the House Judiciary Committee report, which specifically identifies this as a problem Congress was trying to solve. And you can see it if you look at pages 8 to 18 of the amicus briefs submitted by the former immigration judges and BIA members, which explains in detail the massive administrative problems that are caused by the two-step notice process. So I think Congress was trying to solve those problems. And then this court specifically noted in Pereira that providing time and place information separately from the rest of the information in the statute can cause confusion, and it's cleaner and more straightforward for non-citizens to receive one document with all of this information that they can take to a lawyer or analyze themselves, and not require them to sort of piece together assorted information about the removal proceeding that are served over time.
And so why is it that the ability of the government, because it's specified by statute, to change the time and place by telling the alien that, why doesn't that destroy your argument?
Sure. Well, so first of all, I think it's just necessary to have some ability to change the hearing date, but also having some sort of date certain on the initial notice is extremely valuable, because it means that if the subsequent hearing notice, so imagine there's no date on the initial notice, then if there's a problem serving the subsequent hearing notice, then the person's in limbo and there's no date at which they'll ever show up in immigration court. But if there's a date on the initial hearing notice, even if it gets changed, imagine it gets changed and that subsequent hearing notice isn't properly served, well, then the non-citizen still has to show up on the initially noticed date, and when that person arrives in immigration court, any confusion can be resolved, and the person can then be given in person notice of the new date.
And that person already knows all the rights that the notice to appear has given them.
Exactly. That person already knows all the other information.
Yeah. Justice Kagan?
Mr. Zimmer, if I could start right there, because I'm not quite sure I understand the point. As I understood, you said, well, that it's less confusing because if the change in date never arrives, at least there's the date on the initial hearing notice. But I mean, that could happen, but I would think what's more likely is that a change in date does arrive, and that seems more confusing, to have the date change and maybe change more than once. So who are we helping here, really?
Well, so I think the first, frankly, I think that Congress was most concerned with helping immigration courts and making sure and sort of ending with this two-step notice process that was causing significant problems, was causing all of these unnecessary fights, because non-citizens would show up in court and say, I never received a hearing notice. If there's a date on the initial notice, you can't say that, because at the very least you're required to show up on that date. So I think that, frankly, was what Congress's primary goal was. In terms of but I do think that Congress was also intending to help non-citizens in the sense that, yes, the hearing date can change, but I don't think there's any reason to think that if the government does its job, does what it frankly has told this court it is already now doing in light of Pereira, if the government does its job, then in a lot of cases the hearing date won't change, and you will have a notice document that has all of the information, including the date of the hearing. I just think it would have been too much to ask, understandably, that the government, once they put a hearing date on, that there's nothing they could do to change it. So I think that's just sort of bowing to reality, that you could have hearing notices, but I certainly think it's still very helpful to have all this information in one place.
And Mr. Zimmer, you seem to be assuming that on the first document, if your position is accepted, the government will put a date on the first document. But how about if it doesn't? How about if the government responds to a decision in your favor by saying, look, we're going to send the first document without the date, and sometime down the road, when we know the date, we'll send another document, and it will be maybe a document with the date with the old document stapled to it, or maybe we'll just take the old document and stamp the date on it. So,
Right.
would that be permissible?
I think it would be permissible. I think that, I don't think it's what Congress would have expected the government to do, given that this process has a history going back to the 1950s. And I think it's important to keep in mind that for 20 years, from the 1950s to the 1970s, the initial notice document was required to have a date. The government doesn't dispute that, and it complied with that requirement. So, and it didn't do this kind of two-step, put the date on later thing. So I think Congress, yes, it would be permissible. I don't think it's what Congress would have, sort of the way Congress anticipated that the system worked. And again, I know that if you look at pages 41 to 42 of the government's brief, that's not what the government's doing. It is actually doing exactly what I described and providing, an accurate date up front.
Thank you, Mr. Zimmer.
Justice Gorsuch?
Good morning, Mr. Zimmer, and welcome back. Sure seems a little bit like Pereira Groundhog Day to me. I guess I'm curious what your response is to the government's argument that it should just win under Chevron Step 2 at a minimum. No harm, no foul, good enough for government work. If it's ambiguous, the tie goes to the government. Why should we care?
Sure. So let me just give two responses. The first, Justice Gorsuch, is that it's not ambiguous, and I think that that if you just look at what
put that one aside for a moment.
Got it. Yeah. So then I think that assuming there is some ambiguity, I think my primary argument would be that what you have here is under Encino Motor Cars, the agency can't just sort of flip-flop back and forth between positions without explaining itself and yet claim deference. And that's exactly what's going on here. If you look at the post-IRIRA rulemaking, and this is at page 53A of our statutory and regulatory appendix, it specifically, right after IRIRA, the government in rulemaking stated that the language of the amended act indicates that the time and place of the hearing must be on the notice to appear, and that's notice to appear with capitals, which the government admits is a specific notice document. And then in matter of Camarillo, the BIA says the same thing, that it's a specific notice document. In matter of Ordaz, the BIA says the same thing again. And then in Mendoza-Hernandez, after Pereira, suddenly it reaches the opposite conclusion, but it doesn't even acknowledge these prior decisions. It addresses them in a largely unexplained footnote, footnote 8, which just describes them as flawed. And I think this is a classic example where the agency has made an unexplained change of position and is not entitled to deference. Just its latest decision is not entitled to deference. I also think that the reasoning in Mendoza-Hernandez is really just based almost entirely, it basically ignores the statute's text. It completely ignores the statute's history. It doesn't even acknowledge the changes that IRIRA made, even though those changes were addressed in the agency dissent. And that type of reasoning it's not the type of reasonable approach to statutory interpretation that this court requires and shouldn't be entitled to deference for those reasons too. And then last, although I don't think the court needs to reach this question given all these other issues, but we do think that if necessary, as we explained in our brief, that the court could reconsider and should reconsider whether sort of deference to an administrative, to the BIA's interpretation of pure questions of statutory interpretation should really ever be entitled to deference, since it doesn't really have any advantage over this court in interpreting statutes. And this is a proceeding that basically takes place in secret. This is an opinion that basically came out of the blue. No one other than the parties knew that the agency was even considering this question. There was no opportunity for public input, let alone public input as to whether the agency was going to change its longstanding position on this.
Thank you.
Justice Kavanaugh?
Thank you, and good morning, Mr. Zimmer. I want to pick up on what Justice Thomas was saying. The statute requires written notice, and as I understand it, your client did receive written notice of everything in Section 1229A. So why doesn't that end the case?
Right, because I think that if you read that language in context, I don't think that even if you sort of take out everything else, I think that if you're talking about written notice specifying a set of interrelated information about the initiation of a legal proceeding, I don't think that language is entirely clear. I think you can read it as requiring, you can read it either way, as requiring a specific notice document or as allowing the government to use multiple documents. And that's why it's so important to look to these other interpretive tools, like looking to the defined term itself, where it talks about a notice to appear, and like the history. And I'd note, Justice Kavanaugh, that this phrase written notice was copied directly from the pre-IRIRA statute. So it was copied directly from the prior definition of an order to show cause. And I really don't think there's any way to read that statute as not requiring a specific notice document.
I'm sorry to interrupt, but you're relying obviously on a notice to appear in the parenthetical, which does not, as Justice Thomas said, necessarily account for the term written notice in the text. I take your point about the context and the history. But also the problem I think that the Chief Justice and Justice Alito and Justice Sotomayor were raising or asking about was that how does this make much sense in the real world? Let me just follow up on their questions. If you gave notice with everything, including the time and place, and then sent a second document with a new time and place, that's okay, correct?
Yes, that's specifically allowed by the statute, yes.
Exactly. So, but if you send a notice without the time and place and then send the second document with the new time and place, that's not okay in your view?
Absolutely, but that makes perfect sense given what Congress, the changes that Congress made in IRIRA, because the whole problem that was being addressed here was that there were all of these unnecessary disputes. That Congress was sick of these disputes about whether that.
Weren't the disputes arising on removal in absentia proceedings?
Exactly. Yeah, that's exactly right. But that's the whole point here, because what would happen is there would be no time and place in the initial notice document, and then the government would try to serve a separate hearing notice, and then there'd be a fight about whether that hearing notice was properly, basically the person would claim they didn't get the hearing notice, and that's why they didn't show up.
Congress was trying to cut off avenues for immigrants to argue against removal in absentia.
Well, I think it was trying to avoid those fights, and I think it was. I'm not sure that's exactly right, Your Honor. I think it was trying to avoid.
One last question, I just want to get it in, which is you've relied a lot on the history, the legislative and statutory history, but the conference report says that this section is designed to, quote, restate the provisions, end quote, of current law.
Right. Right. I mean, it largely does, but I don't think that there's any way you can read. I mean, there are clearly, as Pereira makes clear, I mean, Pereira explicitly addressed this, there are some changes that were made, and you can't just read those changes out of the statute. So in general, I think in almost all respects, it does restate the provisions of the prior law. But the one significant change it made is removing this language authorizing the two-step notice process. And I think if Congress wanted to allow the government to keep doing what it was doing, there's no reason it would have cut the language that explicitly authorized that practice from the statute.
Thank you, counsel. Justice Barrett?
So, counsel, I take it that under the government's approach, there's no dispute that the stop time rule starts running when notice is complete, so i.e. when the non-citizen receives the time and place of the hearing. Is that correct?
Sorry, just to make, are you saying that we're not disputing that under the government's rule, our client received the notice? Is that what you're asking?
Right. So I'm saying under the government's approach, the stop time rule runs when notice is complete and when the time and place are received.
That's right, yeah.
Okay, so here's my question. Justice Alito was saying, and you agreed, that the stop time rule would run when notice was complete, even if the government used a dummy date or a date that was 99% certain to be changed in the initial notice that contained everything. So why isn't this rule actually worse for non-citizens? Because it'll mean that the stop time rule starts running earlier.
Right. Well, so, Your Honor, this is exactly the issue that this court addressed in Pereira, and I think the court correctly recognized that the government is not going to provide arbitrary dates, but and that Congress wouldn't have assumed that the government would provide arbitrary dates.
You told Justice Alito that would, I mean, even if it's 85% not likely to happen, you told Justice Alito that would satisfy the rule.
No, it absolutely would, and I'm not changing that. I'm just talking about in terms of why Congress would have set up this system, and I think the reason is that it would have that the government generally does not sort of provide arbitrary information to people, and it generally does its best to.
That's true, but if DHS really can't coordinate with immigration courts because it can't put things on their docket, it may have no choice, if the software doesn't handle things in every situation, but to give a date that it hopes for. But this rule would force them to put that date down. Let me go back to Justice Kagan's question. So she pointed out that another way to satisfy this rule would be to send essentially what would be a draft notice containing all information except time and place the first time around. And then later, once the time and place was set, send the notice that would actually trigger the stop time rule that contained all the information. And you conceded that would be sufficient, but you resisted it. And I'm wondering why you're resisting it, because wouldn't it be better, under Justice Kagan's hypothetical, for the immigrant to have more information and to know in the beginning, well, this is what's coming. We're going to be initiating, removal proceedings based on this information, and you can expect to hear the time and date later, and that's when the stop time rule will happen. Why do you resist Justice Kagan's scenario when it would result in the non-citizen getting more information?
Sure. I mean, I don't resist it in the sense that I think that it's clear that Congress preferred that to what the government is doing now. I think that I resisted it only in the sense that I don't think that there's any reason to think that the government can't just provide accurate information in the first place, which is, exactly what this court said in Pereira. And again, if you look at pages 41 to 42 of the government's brief, they're basically doing that now. So I certainly don't resist in the sense that it is far preferable to what's happening now, because the non-citizen does receive at some point all of the information together. I don't think it's even necessary for the government to do that, in the sense that it's told the court it can provide accurate information that it already is, in light of Pereira, is already largely providing accurate information in the initial notice.
Thank you, counsel.
A minute to wrap up, Mr. Zimmer.
Thank you, Mr. Chief Justice. In conclusion, Congress could not have been clearer in IRIRA. The statute used to authorize a two-step notice process, an order to show cause followed by hearing information in the order to show cause or otherwise. And in IRIRA, Congress cut the language authorizing the separate hearing notice and required the time and place information be included in the notice to appear itself. That change only makes sense if both the order to show cause and the notice to appear are specific notice documents. Accepting our interpretation of the statute simply requires that the government do what IRIRA clearly commands. And as I've been describing, the government plainly can do this. Indeed, as I was just mentioning to Justice Barrett, it told the court in its brief at pages 41 to 42 that it has already largely done it. Accepting the government's position, by contrast, would allow the government to reverse the progress it has made since Pereira and continue indefinitely with the very multi-step notice process that IRIRA explicitly cut from the statute, a process that leads to precisely the notice lapses and confusion that Congress sought to avoid. Thank you very much.
Thank you, counsel. Mr. Yang?
Mr. Chief Justice, and may it please the Court, the Board of Immigration Appeals adopted the best reading of the INA in concluding that Section 1229A's written notice requirement permits written notice to be provided in two documents, an NTA form and a notice of hearing. That conclusion flows directly from the statutory text. Section 1229A1's operative text specifies both the content and the form of the required notice. The content is listed in the subparagraphs of paragraph 1, and with respect to form, the statute specifies that it must be in writing and must be served personally or by mail. Congress otherwise left the form of the notice up to the government, and there is no dispute here that petitioner received written notice in that manner conveying all of the relevant information. No sound reason exists for precluding the use of a separate document to specify the time and date of an initial hearing. The government's rule treats similarly situated aliens similarly. If an alien receives all the required notice at the same time as another, it does not matter if the form of that notice is in one document or two. It reflects the standard role of notice provisions, the purpose of which is simply to provide adequate notice. Petitioner, by contrast, would treat differently two aliens who receive notice of all the required categories of information at the same time, based now on whether it's on one envelope or two. That rule is nonsensical, and it is wholly out of step with the result in the design of IRIRA. This court in Pereira rejected the idea that the form of a notice document labeled notice to appear should control, holding instead that the proper focus is on the substance of the information required by statute. The court should do the same here by holding that the statutory text shows the substance of the notice, not its form as one or two documents, controls.
Mr. Yang, you can fix this whole problem, or at least moot the dispute, simply by sending a copy of the notice to appear when you send a notice of when the new hearing date is, or when a hearing date is?
By petitioner's concession, that would satisfy his test, although there are some practical difficulties, and if I can explain those. EOR issues hearing notices as the adjudicator of the charges, and serving an alien with an NTA form containing those charges has traditionally been viewed as a prosecutorial function
not one performed by the neutral adjudicator. For DHS, once EOR issues the hearing notice, it would be administratively difficult to act with sufficient speed to combine the NTA form with that notice and reserve both on the alien. And
why would that, I'm sure you understand the intricacies more than I do, but whoever is sending out the updated notice to appear or the original notice to appear just has to attach what someone has already sent, which is the original notice to appear. Now, if it's the fact that the immigration office has to take the prosecutorial information and staple it together, or the other way around, it doesn't seem to me that that should be terribly administratively burdensome.
Well, on the immigration court side, I think that it has traditionally been viewed, and I think they would view their position as not being one to serve the charges, to facilitate charges. But for DHS, this is the issue. Recall, the hearing has to be set no earlier than the date of the service of the written notice. And if the written notice is the stapled document, that's what we're going by. DHS would have to reserve it. DHS's NTA form is in the alien's physical A file. The physical A file has to be retrieved, and it's not infrequently sent to the National Record Center in Missouri. It has to move from place to place depending on what's going on. If the alien, for instance, seeks some benefit, it's sent to USCIS to adjudicate the benefit. It then might be sent back to the Record Center. So it's not uncommon that this is not local when the notice is issued. Now, we're not saying this can't be done, but it would be burdensome. Now, remember,
thank you for that information. Do you argue that the error is harmless here, or at least will be harmless in many cases?
We're not arguing harmless error here because the question is when the stop time rule stops, when this time stops, not whether there was an error. There would be harmless error arguments in, for instance, if a hearing was held without adequate notice, as determined by this court, we could have a harmless error in that instance. But in the stop time rule, we're not asserting that argument.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Yang, can you give me an example of other places in the U.S. Code or in your practices where you send multiple notices?
Multiple notices. Well, I think I don't have a specific instance in the U.S. Code, but oftentimes there are notice and supplemental notice when there's new information that wasn't originally available. And I think that's the kind of situation that we have here in many contexts. Although in certain non-detained cases, we can issue and do issue a notice to appear with hearing dates. That's not the case, and it's not. It's with many cases. And if I could explain why it's administratively difficult at the time you're issuing an NTA form I'm sorry, Justice, I didn't mean to interrupt. I'm hearing.
No, I think you can proceed.
Okay. So it's administratively difficult, particularly for aliens arrested without a warrant. And this is a very frequent event, particularly at our borders. There are two considerations that are relevant there. First, it's the timing and the hearing and the location of the immigration court. Those things can depend on two things. Whether the alien is on the detained docket or the non-detained docket. The detained docket has to move much more quickly because they're detained, and where the alien will be located during the removal proceedings. The second factor is that the government has to promptly issue an NTA with charges to the arrested alien, which DHS informs us often occurs before it has the detention and location information. So, for instance, on page 42 of our brief, we explain that DHS, by regulation, normally has to decide whether to issue the NTA within 48 hours, and it will serve it on the alien shortly thereafter. It's important to let an alien, an individual who you have detained in the United States, why they are being detained. But when the Border Patrol arrests the alien, and it's the one that issues the NTA because it's the investigating agency and it has knowledge of the charges, the government's detention decision is normally then made by ICE because the Border Patrol doesn't detain the individuals. ICE has to, and it has to make the determination based on its resources. So then ICE has to make the determination, and that's after the NTA is issued. And we don't even know at that point whether the alien will get a bond from an immigration judge.
So, Mr. Yang, I understand the logistical problems, but are you limited to just sending 2 or 3 documents? Could you send 7 or 8 or 9 different documents?
There's nothing that textually limits us, but there are practical considerations. As we explained, remember, we're talking about a volume here of like 500,000 NTAs per year. That's about 10,000 a week or 2,000 a day on average. There is no interest in the government to balkanize the notice, the written notice it has to provide, because it multiplies our effort and introduces all kinds of potential for error. And there's never been any indication that the government ever does this except for the hearing notice. The hearing notice.
Justice Breyer?
As far as I understand this, and there's a statute, it says that written notice, which means a notice to appear, shall be sent to the alien containing a number of things, and one of them is the time and the place of hearing. So it seems to me if you read it, it says send a notice, not 4 notices, a notice to appear which contains the following. All right, and if you look at it practically, you say, well, if you have more than one document with some of this information, people are going to get mixed up. The aliens might get mixed up. On the other hand, it's more burdensome to the government. So I see things on both sides of the practicalities of it, so why don't we just go with the language?
Well, I guess there's a few things that you've asked there. One is about the practicalities, and I can address that second, because I actually think petitioner's solution is worse than providing clear indication that you're going to have a second notice with time and date information, and because you're going to have a date that's not correct. So I think his solution is actually the worst for aliens. But the main point is the text. The text is not quite as I think you may have suggested in the question. The text says that in removal proceedings, written notice in this section referred to as a notice to appear. So only in this section, this is a definitional, shorthand. In this section referred to as a notice to appear shall be given containing the information. The operative text doesn't have an A. It simply provides that written notice is required. We don't think the A really matters either way, but petitioner's argument hinges on it. But if you look at the next paragraph, in paragraph 2, Congress talks about requiring a written notice. Now, if that's true, Congress's omission in the operative text in 1 certainly must have import under petitioner's theory. But clearly it does not. Not only that, if you look to just the way that collective singular terms are used when we're talking about collections of information, it's quite typical for Congress to have used a notice to appear because that can naturally refer to multiple documents. We cited an Oregon Supreme Court decision called Bonds. It talks about multiple documents comprising a notice to arbitrate. We cite that not because the case is a holding of a statute. It just illustrates that this is a typical way to refer to informational singular terms. And it would be pretty backwards for Congress to say written notice is required in this section referred to as a notice to appear and have that article intended to unambiguously, as petitioner says. That article unambiguously shows that you need 1 document versus 2. It just doesn't seem to be within the realm of, certainly not unambiguous, but the much better argument is the otherwise, which is that written notice is required. And when that's particularly true when you look at the function of the stop time rule. Congress wanted to stop the accrual of time that aliens were collecting during removal proceedings and make sure that the government was serious enough by providing notice both of the charges and the scheduled hearing. But that function isn't served by saying whether it's in 1 document or 2. All it requires, like any notice requirement, is that you give notice to the alien. And if the alien doesn't get notice, the alien has a remedy. The alien, if there is an intensive proceedings, the alien can come in at any time, immediately stops a removal, and the alien can show that the alien didn't receive the required notice.
Thank you, counsel. Justice Alito?
Mr. Yang, I gather that the decision in this case will be important for a number of cases that arose before Pereira, maybe for some time after that. But what is the importance of the question for cases going forward? Mr. Zimmer says that the government is now providing time and place in the notice to appear. So what is the significance of this case for future cases?
So the pipeline cases, there's about 1.2 million cases pending before the EOR at this point. But with respect to the prospective cases, the problem is that we are not providing the hearing information on our NTA form for a substantial number. We don't track this, but the best estimates that we have are in any given month or so, maybe a third of the non-detained cases, only non-detained cases, will have NTAs. Remember, I think I was discussing with Justice Thomas, there are problems about when you issue the NTA, you don't have information for an arrested alien. When you have to issue that NTA promptly, and this is at page, we cite the reg at 287.3D at 42 of our brief, you have to issue that notice to appear promptly, but the Border Patrol is not going to be able to determine at that time whether the alien is going to be detained, where the alien will be, and as a result, whether you put them on the detained or the non-detained docket. Now, the non-detained docket moves much more slowly. The detained docket, for good reasons, has to move quickly. If we had to put everybody temporarily in our custody on the detained docket, that would risk clogging the detained docket with all of these cases with aliens that simply are no longer detained, and it would slow the whole process down for aliens who actually are detained. And when this is, again, at page 42 of our brief, EOR attempted to have the automated scheduling system operate for its detained docket. But as we explained in our brief, the operational logistics were impossible to overcome because of the fluctuation in the detained population.
Well, Mr. Zimmer says you have an easy solution. You could just ascertain what is the average time between the service of a notice to appear and the date and the time and place, and put that on the notice to appear. And that would invoke the stop time rule. If it turns out to be inaccurate, even 99% of the time, that doesn't bother him.
No, I understand that position, but I think that just highlights how absurd this all is. Because if petitioner's problem is solved by setting a date, say 3 years in the future or something, and then resetting the date with the hearing notice, they still have to get notice of the served hearing notice, and that should solve the problem. From legislative history, which does not support the proposition, he thinks that Congress was concerned about disputes about the hearing notice. But the legislative history doesn't resolve that. Congress specifically addressed everything that it thought was important without providing any kind of clear one-document rule. It provided a remedy for the alien if there was a problem with service. It provided for substantive information that must be provided before the hearing, or certainly before in absentia removal, or in this case to trigger the stop time rule.
Thank you, Mr. Yang.
Justice Sotomayor?
Mr. Yang, it is somewhat an unusual situation, because it's not as if the rule that the other side is asking us to implement stops the alien from being detained or changes the course of his or her hearing. Everything goes on. The only issue is whether the government gets the benefit of the stopgap rule. And there, the other side says there is an inherent value in having all of the information that is specified under the statute explicitly. It says a notice to appear must include these 6 or 7 or 8 items. And that's what entitles you to the benefit the statute confers against the alien and on the government. And you haven't really answered for me why that makes no sense, and why your argument that you would be entitled to send out 7 or 8 pieces of paper each one containing the individual items required under the statute. And then when you got to the end of all of them, the stopgap rule comes into effect, but the alien can't really know because it can't control you from sending those notices out a month, 2 months, 3 months apart, 6 months apart, 8 months apart. At some point, the alien's not going to know what you're talking about when you send the piece of paper. So please tell me why your logic makes more sense than the common sense logic of the statute says a notice to appear must have all of these items in it.
Well, I think one of the premises is quite wrong, which is that Congress was intending this just to apply to the question of the stop time rule. The notice requirements apply much more broadly. And stop time rule, remember, only applies at most to affect 4,000 aliens per year. The more critical thing is in absentia removal. In absentia removal is also triggered by the written notice required in subsection in paragraph 1. And Congress was concerned there, making sure that aliens could be removed in absentia.
Well, that's the point. Isn't that the point, though? Wouldn't it? That's exactly what your adversary is saying.
No, it's exactly the opposite. Congress wanted to remove aliens and provided a remedy if they didn't get the notice. The remedy is that you can come in and you can say, I didn't obtain the notice that was required.
They still have that remedy, but if you give them that information all at once, they no longer have a defense if they fail to show up at the specified hearing date. That's what your adversary is saying. Congress was intending to cut that argument off.
There were 10 hearing notices in this case. That's not terribly unexceptional, right? Things get rescheduled. The date and time is going to change in almost every immigration hearing. There's usually a master calendar hearing that starts off, and they schedule different hearings later. The idea that you would have to have it all in one document, particularly when Congress in 1229A2 provides for separate hearing notice later, is an odd argument, particularly when the requirement is simply that of written notice.
Thank you, counsel. Justice Kagan?
Mr. Yang, your answer to Justice Thomas suggests to me that your statutory interpretation must be wrong. In other words, the idea that the government could separate out notice into 7 different documents if it wanted to. You know, the nature of the proceedings would be in one document and the charges would be in another document and so forth and so on. I mean, that just seems wrong to me. And so that makes me look harder at the statutory language. And indeed, the statutory language seems to cut very much against you, that there is a definition here of the phrase notice to appear. And the statutory definition says that that phrase means written notice specifying the following things. And if we do what we usually do with a statutory definition, we just sort of plug in the definition in place of the defined term, we get a pretty clear answer on the stop time rule, that the period of presence ends when the alien is served A, and then you substitute this language, a written notice specifying the following. And that seems pretty clear to me. It's a written notice specifying the following. One piece of paper specifying the following.
Justice Kagan, I think it's exactly backwards. The defined term is notice to appear. The definition does not have the article A. The definition is...
No, but the definition doesn't have the article A, but the stop time rule does have the article A. In other words, the definition, the defined phrase is simply notice to appear. And so then you would put in written notice specifying the following. You already have the article A in the defined term, in the operative statute. Then the definition comes after that A. But if you read it as a whole, it's a written notice specifying the following.
But Justice Kagan, that A is in the parenthetical that talks about in this section referred to as a notice to appear.
It is not. The quotation marks are only around notice to appear. That's the defined term. And so that's what you plug in.
even petitioner is not making that argument, Justice Kagan.
Whatever the petitioner is making, that's the right way to read this definition.
Well, no, I think that's not quite right. If you take the parenthetical for what it's worth, it says in this section referred to as a notice to appear.
Notice to appear is the thing in quotes. That's what you're substituting written notice specifying the following for.
No, I understand that, but if you look, obviously, with the quotes notice to appear, Congress included the article there. And the idea that Congress, when it would put the article again in front of that defined term, it does later on, when in the stop time rule, it doesn't add anything to this. It's simply the same thing with the quote.
I mean, it seems to me this is perfectly clear. The way you want us to read it, you would say, well, when the alien is served a notice to appear. But anyway, I think it's pretty clear, Mr. Yang. But if you said a notice of appeal, right? Do you think that you could? Let's say that there was language that said that the losing party in a lawsuit has to provide written notice appealing a decision within 30 days. Do you? And even that, this is without the parenthetical. And suppose somebody said, okay, I'm going to send you two pieces of paper. And the first piece of paper, I'm going to give you my name. And the second piece of paper, I'm going to give you the judgment that I'm appealing from. How would that work out?
Well, actually, I think that's a fairly helpful hypothetical for us because this court has already addressed notices to appeal. And when they omit the signature requirement that was required to be on it, the court determined that that's okay. You can do that after the fact. And that the essential question is that whether notice is adequately conveyed. And
Thank you, counsel. Justice Gorsuch?
Mr. Yang, I'd like to just step back a moment. And, I guess I'm curious why the government is pursuing this at all, given Pereira. I know it doesn't squarely address this, but I would have thought the government might have taken the hint from an 8-justice majority in Pereira that a notice of appeal means what it seems to mean.
Well, if we had thought that Pereira actually says that, we would accept it. But we don't think it does, and we think the text supports our position best. And in addition, although we can provide a hearing date on certain non-detained aliens, for instance, an alien who's not going to be detained because they've already been in the country and they applied for a benefit and it's denied, and it, as a matter of course,
government, Mr. Yang, doesn't have to argue every possible jot and tittle of a statute. It has discretion here. It's just interesting to me that it's chosen to exercise it the way it has. Let me ask you this: what if I had a law clerk and I said in my law clerk manual, I want a bench memorandum analyzing the facts, the law, and your proposed disposition, and instead of providing that, my law clerk provided 3 separate memos, each detailing various views of the facts, 4 more on the law, and then, I don't know, a couple on proposed dispositions. Would that be a bench memorandum?
It might be, but I think in the context that would probably
an ordinary speaker of the English language think that's a bench memorandum?
Maybe not, but you could certainly say a notice could be provided by telling you when, which memo to write, and then in a separate instruction when to provide it.
Let me ask you this about the government has actually mustered the courage to make a Chevron Step 2 argument here, which is interesting to me. Why should the government get, if there's ambiguity here at the end of the day, after we exhaust everything, why should the government presumptively win? What about St. Cyr and the deportation canon that suggests that ambiguity should be resolved in favor of presumptively free individual?
We don't think that St. Cyr actually stands for that proposition. In St. Cyr, the court concluded that the presumption against retroactivity eliminated all the ambiguity, and that, and in addition, there was this one sentence that mentioned some immigration principle for to benefit the alien, but we don't think in the cases that the court has addressed in the Chevron context, the canon or the principle that the petitioner relies on just doesn't resolve the case. It is a tie-breaking rule.
Last question then arises from that is, how much ambiguity do we need to have in the government's view before we resort to Chevron Step 2? Tie? Do you want us to use some adjectives? Grievous?
Well,
irreconcilable? What's the government's view on when Chevron Step 2 is triggered?
Well, Chevron Step 2, the court has repeatedly said that it just requires ambiguity on the question. And then that goes to the agency. The question then is whether the agency reasonably resolves it. And particularly—
Thank you.
Justice Kavanaugh?
Good morning, Mr. Yang. I just want to make sure I understand the ramifications here of each side's position. If you were to lose, the IJ, the immigration judge, could still reject cancellation of removal and remove the non-citizen. It would just be discretionary rather than mandatory. Is that correct?
That is true, but I would hesitate to note that one of Congress's key purposes in imposing these limitations on eligibility is to remove the ability for executive discretion. This court previously addressed suspension of deportation, which is the predecessor provision that cancellation of removal replaced, and narrowed the eligibility requirements in a case called INS versus Pinpatia at 464 U.S. 183. And at page 185, the court said that the eligibility provisions were adopted, quote, specifically to restrict the opportunity for discretionary administrative action. And then the court goes on to say construing the act to broaden that discretion is, quote, fundamentally inconsistent with that intent. And when Congress in 1996 then ratcheted down eligibility yet further, Congress certainly was not intending to just throw to the wind those eligibility requirements when it's possible that the executive could exercise its discretion in the same way. It had that choice in 96, but chose not to go that route.
To follow up on something Justice Thomas raised and then Justice Kagan followed up on, and just to make sure I understand your answer on the 6 or 7 notices point, I understood you to say, but correct me if I'm wrong, that the actual operation of the system and the structure of the overall statute operates as a deterrent on the government doing any such thing, because it just makes no sense for the government to do that. I think that's what I understood you to say, and I want to make sure I understand that.
I think that's exactly right. Remember, now we're talking about a system that has to process about 500,000 notices to appear per year. That's about 2,000 per day. And the idea that we would, take what is a preset form with everything except the hearing date, because we can't always provide the hearing date effectively, practically, when we're doing that at an early stage, and all of a sudden break it into, 8 or 10 different documents, each of which, remember, we have to document we served the alien, so we have to keep evidence of service of all of these things, proper service, that we then have the burden of establishing when we want to remove the alien who doesn't appear in absentia. It's that fanciful to think that the government would ever do that. We want to do this as efficiently as possible.
I'm sorry, one last thing, Mr. Yang. I think Justice Kagan was suggesting that if your textual argument were right, the quote mark should be around a notice to appear, not just around notice to appear. Can you follow up on that?
Yeah, I mean, I see the point that she makes, but I don't think that the Congress, by providing a notice to appear, is simply a reference. And so whether it included the A in the quote or not, it simply said in this section is referred to as a notice to appear. When Congress did that, and then later in, first of all, it's in this section, so the stop time rule is not this section. And this court determined that 1229BD5, which is the stop time rule, that was a reference. It says a notice to appear, served a notice to appear under Section 1229A.
It's no longer Justice Barrett.
Mr. Yang, I want to go back to the difficulty that you described when aliens are detained by border agents. You were talking about this in response to some questions by Justice Thomas. And you said in that case you have to issue the NTA immediately or within 48 hours, but you don't necessarily know at that point where the detention facility will be. So here's my question. I mean, presumably now you're handling that by within 48 hours issuing a notice to appear that has all information except the time and the place of the hearing. Why can't you then, once the alien is put in a detention facility, at that point issue an NTA that has all the information, because now they're in a detention facility and you know where they are?
So we would then be issuing 2 notices to appear, one with a hearing date later. the reason and I'm not saying that's not possible, but the reason that it's difficult is because the marrying up of written notices with the physical A file, the NTA form, and doing that on the volume that we're talking about, plus within the timeline. Remember, if you want to schedule these hearings promptly, you can do it within 10 days of service of the written notice under 1229A. But when the immigration court sets a hearing date, it may not know how long it's going to take to get that service to appear.
No. I'm not saying you rely on the immigration court setting the date. I'm saying that once a non-citizen is put in a detention facility, can't DHS at that point? You know, Justice Alito talked about issuing notices to appear that maybe have estimated dates. I mean, couldn't you do that at that point?
You could, but you still have the additional problem that, one, the aliens, well, I take it back. In theory, you could. You have the additional problem that aliens will bond out and you will have holes in the docket. The second problem is just logistical. The immigration court had tried to put the detained docket on an automated system, and they just found the obstacles too great because of the fluctuations in the population. They tell me that the real issue is efficiently scheduling these hearings close together. If you have all these gaps, you end up having inefficient allocation, and that results in people waiting longer for hearings. So the EOR would have to change its system to automate it back to the system that they already determined, this is on page 42 of our brief, was not practicable with respect to the detained docket. Now, once they're non-detained, I guess you could do it again, but you've got the same problem because
Counsel, before my time expires, let me ask you one other question. You said that part of the problem in having the immigration court issue the complete notice to appear that would have the time and date is that the immigration court doesn't like issuing the charges. So part of this seems to derive from the separation between DHS and then having the immigration court's house within DOJ. But is that just reluctance on the part of the immigration court? Couldn't the immigration court simply include a copy of what you've already sent to the non-citizen and then on a separate document notice the time and place of the hearing and put them in the same envelope?
Certainly, if we were to lose that case, that would have to be considered. But I can say, I mean, we've gone through this pretty clearly with the EOR on this, and there's a strong view as the neutral adjudicator they should not be taking steps that facilitate the prosecution.
Thank you. Mr. Yang, would you take a minute for rebuttal?
Thank you, Mr. Chief Justice. Congress specified in 1229A that written notice should be required, and Congress specified both the form and the substance of the notice. The form is that it has to be in writing, and it has to be served either personally or by mail. There is no dispute the petitioner received written notice of all of the information required in 1229A. That should be the end of the matter.
Thank you, Mr. Yang. Mr. Zimmer, you have 3 minutes for rebuttal.
Thank you, Mr. Chief Justice. I think ultimately it's revealing what the government does and does not say about the statute. I mean, ultimately, the government effectively admits that its position would allow it to chop this, all of this information up however it wants. I mean, it could provide, as we explained in our brief, if the government's right that all it has to do is provide written notice in some form, it could provide all of the non-case specific information to every single non-citizen who enters the country and leave that out when it provides the specific charging information. And ultimately, all the government can say is, well, trust us not to do that. And that's generally not, the way that this court, would interpret statutes to sort of to have absurd results that just because you trust the government not to sort of carry out those results. And then ultimately, much of Mr. Yang's argument was just focused on the fact that this is hard to do. But ultimately, maybe this is hard to do. I mean, I can't dispute much of what he said, but the government doesn't get to avoid doing things just because they're hard to do. And if prior to IRIRA, the statute specifically authorized the government to use the system it's defending here. It specifically told the government it could provide this time and place information in a separate hearing document. And in IRIRA, for whatever reason, Congress changed its mind, and it moved that time and place information from an optional part of the order to show cause to a required part of the notice to appear. And again, as I emphasized before, the government has known this from day one. In its post-IRIRA rulemaking, and this is at page 53A of our statutory appendix, in interpreting IRIRA, the government itself stated, and this is a direct quote, it recognized, quote, the language of the amended act indicating that the time and place of the hearing must be on the notice to appear. So maybe this was a hard problem, but it was a hard problem that the government knew from day one it was required by the statute to solve. And if the government ultimately decided that it couldn't solve that problem, its response was not to make the unilateral decision to ignore what it conceded to be Congress's clear instructions. Its solution was to go back to Congress and ask it to change the statute back to what it had said before. The government should not be able to now ask this court to effectively bail it out from its failure to do what it knew it required by asking this court to adopt exactly the opposite interpretation of the statute that the government itself gave it right after it was enacted. Thank you very much.
Thank you, counsel. The case is submitted. We will hear argument next in case 19-546, Brownback versus King. Mr. Houston.
Mr. Chief Justice, and may it please the Court, the text of the FTCA judgment bar resolves this case. The district court entered the judgment in an action under Section 1346B, so that judgment constitutes a complete bar to any action by a respondent against the federal employees involved in his FTCA claim. That broad text unambiguously precludes respondent's Bivens action here, which asserts the same injuries based on the very same subject matter. The Sixth Circuit's refusal to apply the judgment bar in this case rested on two propositions. First, that when the United States prevails in an FTCA action, the district court must necessarily dismiss for lack of subject matter jurisdiction. And second, that such a jurisdictional dismissal does not trigger the judgment bar. Both propositions are wrong. This court rejected the Sixth Circuit's jurisdictional analysis in FDIC v. Meyer, But even more important for present purposes, this court in Simmons v. Himmelreich squarely rejected the Sixth Circuit's conclusion that the judgment bar never applies to an FTCA judgment for the government. The court held instead that the judgment bar does apply where a plaintiff simply fails to prove his claim. And that conclusion follows directly from the text of Section 2676, which makes, quote, the judgment in an FTCA action preclusive without drawing any distinction based on which side prevails. Respondent now concedes that the Sixth Circuit's reasoning cannot be reconciled with Simmons, so he shifts to an alternative argument. He says he should be able to bring an FTCA action and an individual action together without the judgment bar coming into play. But the statutory text directly refutes that argument too. Whereas common law res judicata made a judgment preclusive, quote, in a subsequent action, Congress in the judgment bar expressly departed from that rule and prohibited any individual action following an FTCA judgment. That's because Congress wrote the judgment bar to prevent duplicative litigation against the government's employees, and that objective does not depend on whether the plaintiff's individual action is brought with the same case number or a different one. The judgment below should be reversed.
Mr. Houston, I want to ask you about your last point. As you read the statute, the disposition of an FTCA claim bars Bivens claims against the employee. But of course, the statute speaks of actions, not claims, and it was and is very well established that there's no bar with respect to claims in the same action. If Congress were going to make such a dramatic departure from that rule, the obvious word to use is right there. It's claims, and yet they didn't do that.
If I might make 2 points about that, Your Honor. The first is that, as I just said, you're right that the common law rule was that a judgment in a subsequent action is preclusive. But I think you can see that Congress made exactly the type of express departure from the common law that Your Honor mentioned, because it deleted the word subsequent, which you will find in the first restatement in this court's cases over and over again. Congress removed the word subsequent action and replaced it with a complete bar to any action.
I don't know that that's the clearest way they could go about it. The clearest way to go about it would say claim. It would be a complete bar to any claim that is raised, as opposed to any subsequent action. That's where the real departure is, and it seems to me that that's a much more direct way to eliminate any confusion than simply deleting the subsequent that appeared in some cases.
Well, Your Honor, in 1946, as we explained in our reply brief at page 8, the definition of the term action was a demand for relief in court. And I think you can see that Section 2676 uses the term action to be essentially synonymous with claim, because it refers to an action under Section 1346B. And so it's clearly tying the word action to specific causes of action. But again, I think if you put the common law, the classic canonical formulation of res judicata side by side with this statute, the key difference you see is the deletion of the word subsequent and the replacement with the word any. So I think it's not surprising that Congress would refer to preclusion of an action, because that's traditional common law res judicata. What the difference was that they eliminated the requirement that preclusion would occur only in a subsequent action and made it a complete bar to any action. And that, of course, accords directly with Congress's purpose, because from the standpoint of preventing duplicative litigation against the federal employees, it makes absolutely no difference whether the duplicative individual action is filed together in the same lawsuit with the FTCA action or separately. And
Thank you, counsel. Justice Thomas.
Thank you, Mr. Chief Justice. Mr. Houston, I'd like to pick up on your last point. Now, in this case, the respondent filed the Bivens action together with the FTCA action. And though the argument seems to have just disappeared and then reappeared here, respondent now argues that if he loses on the FTCA claim, that he has the alternative argument that since these were filed together, the outcome should be different from a case in which they were filed separately or sequentially. What would be your argument there? First, can he even make that argument now? And two, if you can, would you elaborate more on your response to that?
Absolutely, Justice Thomas. To your first question, I think it's clear that respondent did not develop this argument in anything like the way that he did in his brief below. Whether he waived it or not, we haven't taken a position on that. He gestured at the idea that this litigation wasn't duplicative because he only filed one lawsuit. But certainly, this is largely an argument that's been developed in his brief in this court. To your question about why I think the text makes clear that that's not allowed, in addition to the point I was just making to the Chief Justice about the way in which Congress expressly departed from the common law by changing the formulation, I think the implications of respondent's position are striking, and the reason why every single court of appeals has rejected respondent's argument in the 70 years since the judgment bar was enacted is that his argument would permit him actually to litigate under the FTCA and prevail to win a judgment against the United States, and then seek additional damages against the government's employees, for example, punitive damages, just because he brought the actions together in the same lawsuit. But we know from this court's decision in Gilman that that result is precisely what Congress created the judgment bar to avoid. And that's because the policy of the judgment bar is one of repose. Congress found that lawsuits against the government's employees are extremely burdensome, and it wanted to limit them without precluding them entirely by saying that if a plaintiff chooses to take advantage of the FTCA cause of action, then the judgment in that action will bring repose to the entire controversy.
On the point of what sort of judgment in an action is included, would a judgment that is still appealable also have the same preclusive effect?
Yes, Your Honor. I think the definition of judgment in Section 26 is the same as the definition of the word judgment in the Federal Rules of Civil Procedure. It is the order of a district court that is appealable. Now, of course, that means that if a plaintiff succeeds in appealing an FTCA judgment and gets it vacated by a court of appeals, at that point, there no longer is a judgment in an action under Section 1346B, and therefore the judgment bar would no longer apply. But while the judgment entered by the district court is in force, and of course in this case that judgment is final, that judgment by the plain text is a complete bar to any individual action against the federal employees.
Thank you.
Justice Breyer.
Thank you. Can you tell me if I have this basically right? Courts of appeals get lots of appeals from district courts, and I thought a judgment is a piece of paper, normally, that the district judge files at the end of a lawsuit, and it says judgment, and it tells you how the lawsuit turned out, who won, and perhaps on what grounds. And here, the judgment in an action under 1346B shall constitute a complete bar. But normally, if you have 4 different claims in the lawsuit, the judgment doesn't come in till the whole thing is over. You might preliminarily decide, or you decide the judge says he's going to lose on this claim, he's going to lose on this claim, maybe he'll win on this claim. As at the very end of the thing, we have a judgment. Isn't that how it works?
Yes, Your Honor. I think that description of the word judgment is right, but that is exactly the judgment that the district court entered here, and you can see that at Petition Appendix 86A. The district court resolved all of the claims in the case. Now, the key to the judgment bar, of course—
the judgment shall constitute a bar to an action of the claimant by reason of the same subject matter, etc. But the judgment didn't appear until after he wanted to pursue his Bivens claim.
Your Honor,
there was no judgment to bar it because the judgment wasn't entered yet.
Respectfully, I disagree, Your Honor. I think the judgment was entered by the district court when it resolved the dispositive motion. It resolved all of the claims in the case, and it entered a judgment. That document, which is at Petition Appendix 86A, that is the thing that triggered the judgment bar. And respondent left that judgment final. With respect, he left the judgment in the action under Section 1346B final by not appealing it. So the core rule of the judgment bar, when that judgment was entered, it precludes any further litigation at that point.
I agree with that. But I mean, wasn't the judge wrong to enter a judgment before he decided the Bivens claim? Or did he decide the Bivens claim in the judgment?
He decided the Bivens claim, Your Honor. The district court resolved.
He decided it. Okay. On what ground did he decide it? He decided it because there was a bar. But at that moment, there wasn't a bar because when he decided it, it was before he entered the judgment. And at that point, there was no judgment.
No, respectfully, Your Honor, the district court's analysis had nothing whatsoever to do with the judgment bar. The district court adjudicated the substance of both the Bivens cause of action and the FTCA cause of action. It never said anything about the judgment bar. The judgment bar was triggered only after the district court entered judgment. And you can see this in the district court opinion.
I have enough to see that I have to sit down and figure this out word by word, which I'll do.
Justice Alito? Assuming the principal argument now made by respondent wasn't forfeited, we have discretion whether to affirm on that alternative ground. And what would you say as to why we should not exercise that discretion?
Because, Your Honor, this court has held repeatedly in interpreting the FTCA that the text means what it says. And in particular, the word any really does mean any, no exceptions. Those are the core lessons of the court's decisions in Simmons, in Hui, in Millbrook, in Ali, and in Smith. And so I think that all the court has to do is say that the language of this statute is intentionally and exceptionally broad. Congress imposed a complete bar to any individual action, and that precludes respondent from bringing a demand for relief under Bivens, regardless of whether it's pleaded separately from or together with the individual action. So I think it's just...
that is an argument on the merits of that issue, isn't it? I'm asking the preliminary question. Why should we even get to that here? We granted cert to decide a particular question, which has to do with the effect of a final judgment. Why should we not, presume most of the time, we answer the question on which we grant a review and not some other question? So that's what I'm asking you. Why should we depart from our normal practice of just deciding the question presented and decide another question, which has been addressed by how many courts of appeals have addressed this issue, and what have they decided?
7 courts of appeals have addressed this argument, Your Honor. Every single one of them has rejected the argument that respondent now makes, that he is entitled to litigate under the FTCA, prevail, and then continue suing the government's employees. So I think Your Honor is exactly right that the reason why you should not exercise discretion to consider this argument is because it simply doesn't warrant the court's review. The only court of appeals that has even come close to accepting respondent's argument is the Ninth Circuit, and the only way that it did that was by building in a rule that the judgment bar depends on which side wins. And that,
let me try to ask one question about the question on which we did grant review. In your view, what is the dividing line between a claim that is not cognizable under 1346b1 and a claim that is cognizable yet fails on the merits?
Well, Your Honor, I think the insight of this court's decision in FDIC v. Meyer is that a cognizable means the same thing as actionable, and a claim is actionable so long as the plaintiff alleges the elements, and that of Section 1346b. And that makes sense because the questions, as this court described in Meyer, The question whether the United States has waived sovereign immunity for a particular type of legal demand for relief is analytically distinct from the question whether the plaintiff can prevail on the merits or even whether he stated a claim for relief under Federal Rule of Civil Procedure 8.
Is it the same test as it would be under a federal question, in a federal question case?
I think that is a perfectly fine analogy, Your Honor. Of course, if a plaintiff pleaded in diversity that his demand for relief was worth more than $75,000, and then it turns out later that he actually has no claim at all at summary judgment, everyone understands that that is a dismissal on the merits of the claim that triggers res judicata, even though we now know at that point that the amount in controversy in the case is zero. No one would think that.
Counsel, Justice Sotomayor?
Counsel, I am a little confused, and perhaps your adversary will unconfuse me. But I don't think every circuit has held that a same suit claims of an FTCA and a Bivens claims means that you can't appeal them. I thought at least the Ninth Circuit has said so. All of the other circuits, I agree with you, have said that if you lose a FTCA claim, you can't file the separate claim. That's not the issue. It's the same claim. But your adversary can tell me what the circuit split is on that question. However, I am going to go back to what Justice Alito raised. You brought the cert petition. I believe that your adversary, in its response, not at length, but it did mention this as an alternative ground not to grant cert, that he could bring the two claims in the same action and not be precluded. And I think the same argument was raised below. Am I correct?
Well, I certainly agree with Your Honor that the respondent raised the argument as an alternative ground in the brief in opposition. The argument, again, in the lower courts, in the Court of Appeals, the respondent did not develop this argument with anything like the argumentation that now appears in this court.
You know something, counsel, that may or may not be true, but it's fully briefed here. It's an issue of law, isn't it? And you can defend a judgment on any legal ground, correct?
Yes, Your Honor, and that's why we have fully briefed.
Now, counsel, let me go on to where the chief started. He said that the FTCA talks about a judgment in an action. In Section 2672 of the FTCA, it says explicitly, acceptance of an administrative settlement with the U.S. shall constitute a complete release of any claim against the United States and against the employee of the government. Seems to me that Congress knew how to say that there was a big difference between a release of a claim rather than a bar to an action. So why should we accept your argument that they meant the same thing when they used different language in two different sections?
Because, Your Honor, the definition of the term action in 1946 when Congress wrote the judgment bar is a demand for relief in court. And I think that if you just substitute that into the text, then the judgment in an action under Section 30.
Counsel, I'm almost out of time, so let me just ask you one last question. As a matter of policy, why would Congress have wanted to go around the common law rule? It seems to me that then happenstance controls. This district court could have ruled the other way, could have said the Bivens claim, the Bivens claims lacking Manning's, the Bivens claim is good, but the FTCA claim is not. And you're still saying there's a bar, correct?
Arguably, Your Honor, I mean, that would be consistent with one of Congress's purpose for the judgment bar to wrap everything up.
Why does that make sense when Congress explicitly in the FTCA and in the Westfall Act saved the Bivens claims?
Because the purpose of the judgment bar, Your Honor, is repose. Congress wanted the judgment in the FTCA action to bring repose to the entire controversy. To your question specifically about Bivens, I think this court addressed that issue directly in We, and just as it said there, the text of the judgment bar is certainly broad enough to preclude causes of action that are both known and unknown when Congress enacted it. I think
Thank you, counsel. Justice Kagan?
Counsel, just a point of clarification first as to the extent of your argument. There are courts in the 7th and the 10th Circuit that have said that the judgment bar can undo even prior final judgments on Bivens claims, so sort of retroactively undo a Bivens judgment. Do you think that that's right?
I think it's possible, Your Honor, because it would be consistent with the goal of the judgment bar to wrap the entire resolution of the claim into the judgment on the FTCA action. Now, I would also understand the contrary argument that when the judgment has been entered in the individual action, there is no more individual action for the judgment bar to preclude. It's, of course, not something that this court has to decide in this case because this is the quintessential example of an FTCA judgment on the merits, and therefore it's the judgment in an action under Section 1346B.
I guess I'm wondering whether your understanding of this provision makes it into something that the language suggests it's not. So if I understand your position correctly, you're really turning this into an election of remedies provision. In other words, that once somebody files an FTCA claim, then really they can't bring a Bivens claim anymore. And the only way to bring a Bivens claim is just to forego the FTCA claim. And that might make sense, you know, as a policy matter to turn this statute into such an election of remedies provision. But the statute doesn't read like that. Congress knows how to write a provision like that. Instead, this statute reads like a preclusion statute. And preclusion, as the Chief Justice began the argument by saying, always applies between suits and not within a single suit.
Well, Your Honor, I really think that Your Honor has it exactly right that the purpose of this statute was to offer plaintiffs in respondent's position a choice. They could either stick with the traditional individual cause of action. They weren't foreclosed from that. But if they choose to take advantage of the FTCA cause of action, which of course opens the opportunity for the plaintiff to recover from the judgment fund, then that choice comes with consequences. And the critical
what I was suggesting, just to make myself clear, is that's a perfectly sensible statute. I guess my question is it the statute that Congress wrote? That Congress wrote a statute. Election of remedy statutes are easy to write. And this is not that. This is a preclusion statute, which has a different set of consequences.
Yes, Your Honor, but the text of the judgment bar is unambiguous. The triggering event is the judgment in an action under Section 1346B, and then what comes next is a extremely broad preclusion provision, a complete bar to any action against the employees. I think the only fair way to read that provision is that Congress told plaintiffs that if they pursue an action under Section 1346B and it goes to judgment, then there can be no further litigation against the federal employees, and that's the same objective.
Justice Gorsuch?
Thank you. No questions.
Justice Kavanaugh?
Good morning, Mr. Houston. I just want to follow up on something Justice Alito raised and then Justice Sotomayor followed up on, which is this alternative argument being before us. We could decide it, but as the court's often said, we're a court of review, not a first view, and there are obviously important exceptions to that principle, but I'm not sure this case really cries out for us to depart from the general principle. So why don't we resolve the question presented as presented in the cert petition, I think was Justice Alito's question, and that's sufficient under the day, and we can worry about the other issue when and if we need to address that.
Justice Kavanaugh, I think that is exactly what the court should do. And the reason why that would be appropriate in this case is that the alternative argument raised by the respondent would not warrant this court's review. As I mentioned, every court of appeals has rejected respondent's position. Now, the Ninth Circuit, as Justice Sotomayor pointed out, has adopted a slightly different rule, not shared by any other circuit, that but that really is just a relic of before Simmons, because the Ninth Circuit's rule is that whether or not the judgment bar is triggered depends on who wins in the FTCA action, and Simmons was absolutely clear that that is not how the judgment bar works, which of course accords with the statutory text. So I think the court should not address the question. There's no need to, because it's not cert-worthy. We addressed it in our brief because it was raised and we wanted the court to have all the arguments, but I think that's a perfectly sensible way to resolve the case.
If we do resolve that question, I'm going to reiterate questions asked by others now, but the key problem for you is it says any action, not any claims. You just want to summarize your best arguments in response to that?
Thank you, Justice Kavanaugh. Yes. Again, the term action is defined in legal dictionaries in 1946 at the relevant time as a demand for relief in court. So I think if you substitute that phrase into the judgment bar, then the judgment in this FTCA action is a complete bar to any demand for relief by the plaintiff under Bivens. And that is just the plain text of that understanding means that there's no room for an exception for that would make preclusion applicable only in a subsequent action. And I just think it's particularly clear that Congress didn't want that subsequent action limitation, because that was in every description of the common law, and Congress changed that formulation expressly.
Thank you.
Justice Barrett?
Counsel, I want to ask you a question about the question on which we granted cert. Did the government make a mistake in moving for dismissal under Rule 12b-1 for lack of jurisdiction as opposed to for judgment on the pleadings, or just, I know they also moved for summary judgment, but why even have the motion to dismiss for lack of jurisdiction in there? And I'll tell you the reason why I'm asking is it seems to me that 1346b gives district courts the jurisdiction to resolve civil actions against the government on the bases that's listed in the statute. And it seems to me that that means that the government is submitting as sovereign to the district court's resolution of those claims either way, whether they win or not. So it's different than, say, in Simmons, where the district court does not have jurisdiction to resolve claims if they involve misconduct in the exercise of a discretionary function. So why did the government even treat this as a jurisdictional issue?
Well, Your Honor, at the time in the Sixth Circuit, there was some precedent that suggested that the resolution of an FTCA claim on the merits would also trigger some jurisdictional implications. Now, we don't think that that's correct. As we explained in our brief, I think Meyer explains, and as Your Honor just explained exactly correctly, the text of Section 1346b refers to jurisdiction over civil actions on claims alleging the FTCA's elements. So, and as Meyer further explained, that's analytically distinct from the question whether the plaintiff is entitled to prevail. But I think what critically matters for the case, in this case, is whether there was the judgment in an action under Section 1346b. And Meyer is perfectly clear that a claim is actionable under Section 1346b so long as the plaintiff alleges the elements, and respondents certainly alleged all the elements of the FTCA claim. You can see that in the complaint at JA 39 and 40. So there's no dispute about what the substance of the judgment was here. And as I think Justice Breyer helpfully explained for the First Circuit in Rose, what matters to preclusion is not the label that gets it, the jurisdictional label that gets attached to something, it's the substance. And Semtec and many of this court's other cases are quite clear that where a district court, as here, adjudicated the substance of the FTCA cause of action, that is a merits determination that's precluded.
Before my time expires, let me just clarify something. So you agree that if, say, the plaintiff had not alleged all the elements and so the claim was dismissed without prejudice under 12b-6, that wouldn't count as a judgment that would trigger the bar?
Absolutely, Your Honor. A dismissal is not a judgment. Those things are not synonymous, as Justice Breyer explained. It is only the entry of judgment that triggers the judgment bar, and that's why the judgment bar was triggered in this case when the district court entered the final judgment at the end of the case Respondent simply chose for his own reasons not to appeal that judgment.
Thank you.
A minute to wrap up, Mr. Houston.
Thank you, Mr. Chief Justice. We've talked already about why our position is compelled by the statutory text and this court's precedent. I want to emphasize for just a moment why it's fundamentally fair. The decision below would permit a plaintiff to bring a lawsuit against the United States, litigate it all the way through summary judgment, lose on the ground that the government's employees did not do what was alleged of them, and then turn around and pursue claims against the same employees using the same factual allegations. That result makes little sense, and it is directly at odds with Congress's objective for the judgment bar, which was to prevent duplicative litigation against the government's employees after an FTCA judgment. Congress's rule in the judgment bar was straightforward. If a plaintiff chooses to litigate an action under Section 1346B, then the judgment in that action will bring repose to the entire controversy. Respondent had a fair chance to obtain damages for his alleged injuries. He didn't recover for the simple reason that he didn't prove his case, and the judgment bar does not allow him to start the case over again against the officers. Thank you.
Thank you, Mr. Houston. Mr. Giacomo?
Mr. Chief Justice, and may it please the Court. Through the text of the FTCA, Congress provides two independent and easily administrable rules that control the application of the judgment bar. First, the judgment bar does not apply to claims brought together in a single action. As Will and Simmons explained, the text of Section 2676 imports common law res judicata. In the history of American law, res judicata has never been applied to claims brought together in a single action. Section 2676's requirement of the judgment in an action, not a judgment on a claim, demonstrates that Congress did not intend the judgment bar to depart from that common law history. Second, the judgment bar does not apply to claims dismissed for lack of jurisdiction. Because Section 1346 restricts FTCA jurisdiction to actions on claims that satisfy 6 elements, the dismissal of an FTCA claim under Rule 12b-6 does not trigger the judgment bar. As Meyer explains, a claim does not come within the FTCA's jurisdiction unless a plaintiff has alleged facts sufficient to state a cause of action under the statute. Thus, a court's holding that a plaintiff has failed to state a claim under the FTCA is not the judgment in an action under Section 1346. It is a holding that the court lacks jurisdiction to enter such a judgment. Both the same claims rule and the jurisdictional rule honor the language Congress enacted in the FTCA. Both present simple, predictable standards that courts and parties can follow, and neither results in duplicative litigation. Under either rule, the judgment bar does not apply to this case. This court should affirm the decision below and allow King to pursue his meritorious constitutional claims in this action, which is the one and only lawsuit King has ever filed. I welcome this court's questions.
Mr. Giacomo, your theory really would combine the merits and jurisdiction, not just in a case like this, but in every case. I mean, if you think you have a claim under a federal question statute, if it turns out you don't, then you would say, okay, well, then there wasn't jurisdiction because I didn't satisfy the elements of the statute that gave rise to a federal question. We've, I think, long held that in a case like this one, where if you make a determination under the merits, there isn't the established jurisdiction against the United States, that they're treated the same. You can't, in other words, whenever you lose, you don't lose because the court had, under your theory, would have had no jurisdiction. That doesn't seem to make much sense.
Yes, Mr. Chief Justice, that's not the extent of our position. We actually offer 3 different ways the court can view jurisdiction, and I'll first state that the reason that it's so complicated is that through Section 1346, as the government agrees, Congress simultaneously waives its sovereign immunity, sets jurisdiction, and provides the elements for a cause of action. So the most narrow way this court could look at that is to look at a case like this and simply say, the district court itself entered a judgment under 12b-1, therefore it concluded, pursuant to Rule 12H3, that it lacked jurisdiction of the subject matter. The middle ground position is the position from Meyer, which is that to trigger the jurisdiction of Section 1346, a claim has to allege a valid cause of action, which is also consistent with this court's dealing with the sovereign immunity statute in Helmerich and Payne. Only in the very broadest understanding, which is brought in through the Arbaugh decision, do any of the concerns that you have raised come to light. And so this court could easily dispose of this jurisdictional question without reaching that furthest ruling. But I'm happy to discuss it further if Your Honor would like to do so.
Well, I guess I don't really understand. I think under your view, a favorable decision for the government would never satisfy the elements of the judgment bar because of the lack of jurisdiction. What am I missing in that?
Yes, Your Honor. No, that's only if this court adopts the Arbaugh standard. We offer two other more restrictive understandings. So only under Arbaugh would that be the case. If this court decides that jurisdiction attaches after a claim passes beyond Rule 12b-6, or if this court decides that jurisdiction has to be decided at Rule 12b-1, either way, a decision favorable or not for the government would trigger the judgment bar.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, why should we even consider your argument that the judgment bar doesn't apply when the claims are brought together?
For several reasons, Your Honor. The first is that that's what the language of the statute requires. But the second is that that question is embedded in the question presented that the government brought to this court. And I'll quote the relevant language. It says, the question presented is whether a final judgment in an action bars a claim. And that necessarily requires this court to consider how that claim is presented. And finally, this is not an issue that has just come up now. The first argument we made in the Sixth Circuit was that the reason the judgment bar shouldn't be applied to this case is because there's no chance of duplicative litigation when claims are brought together in the same action. And as the government has conceded, this is also a point that we made in our brief in opposition to cert when that was filed.
Well, I have one unrelated question, brief question. Should it matter in deciding this case that Bivens didn't exist at the time the judgment bar was enacted?
No, Your Honor, I don't think that has an impact on the outcome of this case, simply because, as we explained in our briefing, since the judgment bar incorporates res judicata, the controlling issue is that King brought all of his claims in a single action. So the subject matter for the action is not at issue here, since the Bivens claim and the FTCA claim are brought in the same lawsuit.
Thank you.
Justice Breyer?
Well, if we did reach this other question, what would you say to what your opposing colleague said? Look, he said, if you read 1346b1, if you read, it says the judgment in any action shall constitute a complete bar. Now, to any government claimant against the employee of the government. Now, that's the point of this statute. You go sue the United States, don't sue the employee. But if you're right, what you could do as a plaintiff is you sue under the statute against the government, you win, and then you go sue against the employee, the very thing that the statute was passed to stop.
No, Your Honor. Our position, even under the broadest understanding of jurisdiction, is that if you bring separate actions and one of them is against the United States and that concludes...
No, you bring the same action. What you do is you have a couple of defendants.
Well, in that case, Your Honor, this would simply be a matter of applying res judicata through the judgment bar, which presents exactly that same scenario where you could sue, for example, an employer and an employee in the same lawsuit. And the disposition of one claim or another wouldn't necessarily foreclose your claim against the other.
Well, that's my problem. The disposition of one against the other. So you win against the employer, the government, and then you go sue the employee. Well, I think if there was one thing this statute was passed to stop, it was that. It was that the United States should take the liability and the employee wouldn't.
Well, Your Honor,
am I wrong about that?
No, but the hypothetical you propose is that the claims are brought together in the same action, so there is no separate going and suing the employee. There's only one lawsuit.
Look, take my point. I'm not interested in exactly how you do it.
Sure.
But if you can get claim one we sue the government. Give us some money. Claim 2, employee, you're involved in this lawsuit too. Give us some money. Okay. Now, that's what I'm worried that your argument here would lead to. And from what you said so far, you say that's just what it would lead to, and that's a good thing.
No, Your Honor. There's no chance, for example, you could get a duplicative recovery.
No, not duplicative. He said extra damages, for example.
Oh, okay. Yes, so this comes down to the fact that as the Westfall Act and this court's decisions in Carlson and Wilkie versus Robbins and Correction Corporation versus Malesko indicate that Bivens and the FTCA provide parallel complementary remedies. So it was exactly what Congress intended
Okay, then your answer is he's right. You could do this, and you're saying Congress did not want to stop all the recoveries against the employee.
Yes, absolutely.
Okay, that's your answer. Thank you very much.
Justice Alito?
If a district court rejects a claim under the FTCA for failure of proof, does the judgment bar apply to that, or is that a jurisdictional determination?
It wouldn't apply in any case if the claims are brought together in the same action, but if they were brought separately...
Well, that wasn't my question. How about if you answer the question I actually asked?
If they were brought separately, Your Honor, the case would have to pursue beyond trial, which is the line that's drawn by Rule 12H2.
The case would have to proceed beyond trial. What does that mean?
It's the standard where a party can no longer raise a 12B6 defense. Rule 12H2 says you can raise that defense up to and at trial, but not beyond it.
Why is 12B6 the dividing line?
Because the language of Section 1346 confers jurisdiction only when there are claims that satisfy the elements of the FTCA.
Why are the elements of the FTCA satisfied up to the not satisfied up to 12B6, but are satisfied after that point?
Because, as this court explained in the Meyer decision, Your Honor, the trigger for jurisdiction is whether a plaintiff has pleaded allegations that set forth a cause of action. And so the failure of proof portion of it, as is noted in the footnote of Meyer, doesn't come into play until there's actually fact-finding being done by the court.
Why was the decision here, in essence, a 12B6 decision?
Well, for several reasons. First, Your Honor, is that the government itself moved under 12B1 and 12B6, and the reason is that the court specifically held it was dismissing the case under Rule 12B1 or alternatively for failure to state a claim under Rule 12B6.
What is the breakdown of the circuits on the question that you would like us to decide?
Yes, Your Honor. So there is only the Ninth Circuit has adopted this same claims argument, but that argument is also consistent with this court's decisions in Will and Simmons, and as we point out in the brief, none of the other courts of appeals, which all have somewhat different analyses of how they get there, actually address the common law aspects of Section 2676, and most of them simply rely on the Manning decision from the Seventh Circuit.
In light of those, 6 circuits that have decided the issue the other way, do you still think the question is so clear that we should decide it, even though it was not the question that we were asked to decide in this case?
Yes, Your Honor, it is that clear. I think the language of Section 2676 and the common law concepts that it incorporates make it very clear. And so the government has essentially come up with its using of the judgment bar in this way in the last couple decades. It's not as if this has been the case since 1946. And so I think this court involvement would be very helpful on this issue.
Thank you.
Justice Sotomayor?
Counsel, I want to separate out the two arguments. The jurisdictional argument, which was the Sixth Circuit's conclusion and the basis of most of the government's argument. Your alternative argument, I call the same case argument. Justice Kavanaugh asked this question earlier, and I posed the same one. Given that it is one circuit against others, has there been sufficient percolation before the court below, the Sixth Circuit, for us to jump in and decide this question now?
Yes, Your Honor.
As a matter of policy, why should we do that? Meaning, it's up to us to decide whether to take to address a ground not decided upon by the court below.
Yes, Your Honor. So although the Sixth Circuit decision below didn't address this issue, the Sixth Circuit has addressed this issue, and I'll concede that it came out on the other side of it. But the reason that this court should address this issue from a policy standpoint is exactly the reasons that this court explained the judgment bar shouldn't operate in the Simmons decision, which is if this court doesn't draw the line on claims in the same action, the result of a decision in favor of the government will be an enormous increase in litigation, and because the government has adopted this peculiar election of remedies that's not really an election of remedies, that litigation will be infinitely more complex, and plaintiffs will be obligated to make it complex to ensure that the FTCA portion or separate action never gets...
Counsel, I do have some practical difficulties with the government's position on the same action, meaning that what the government is encouraging plaintiffs to do is to file their Bivens claims first, win or lose, then file their FTCA claims, and hope that they've won, and that we don't put a bar in like the one that Justice Kagan referred to earlier. That seems somewhat time-consuming. It also makes a difference whether a district court decides whether it's going to decide the Bivens claims first and just say, I don't need to decide the FTCA claims, or try both claims together, win both, give judgment on both, and then go on appeal. There seems variations that are very inefficient. Am I right about that?
Yes, Your Honor. In fact, every variation is very inefficient because, as Your Honor's question indicates, there's no way from an ex post position for a plaintiff to know what it should do to ensure that it can litigate these claims in parallel, even though Congress and this court have both said they can be litigated in parallel.
And that's the answer to Justice Breyer, isn't it? That Congress in both the FTCA and in Westfall have agreed that Bivens claims can and should be brought, correct?
Yes, Your Honor, that's exactly correct.
Unless there's been a bar of a judgment previously.
That's correct.
Justice Kagan?
Yes, Mr. Giacomo, just to continue in this same vein, I mean, what the government is saying about this provision, makes sense in a way. I mean, the government is saying this reflects a broad remedial compromise. Plaintiffs can sue the United States, but in exchange for that, they give up certain remedies against federal employees, and that's the way we should read the provision. And you can well imagine how Congress might have thought that would be a good thing to do. So why shouldn't we read the provision that way?
Yes, Your Honor. I don't dispute that you could make a policy argument for why the Congress should create an exclusive or an election of remedies. But the reason this court shouldn't read it that way is because Congress has not done so and has explicitly carved out the ability of plaintiffs to bring, under the Westfall Act, an FTCA claim and a Bivens claim. And even before then, since 1952 in the Brooks case, this court decided it has said there is not an election of remedies in the FTCA, and it's continued to say that every time it's had the opportunity over the last 70 years.
And if you were just to look at the language of the provision, what would you say about the language of the provision with respect to this question?
Yes, Your Honor. So this gets us back to the distinction between an action and any action. And it's simply a situation where someone has a coupon to go to a grocery store that says, if you buy a case of pop or soda, as people might call it, you get any case free. Of course, a reasonable person would not understand that coupon to mean the first case was free. You have to buy the first case. The government is in this situation asking the court to say that coupon applies to the first case of soda, or in this instance, the first and only action that's ever been brought.
If I understood Mr. Houston's argument, it was that, you might think that we're taking the word action and making it mean claim, and in fact that you might think that the two words are different, but in fact they're not. because Mr. Houston said an action is just a demand for relief in court, when this statute was written. So why isn't that true?
Yes, Your Honor, because the definition that my friend relies on is definitely well outside the mainstream. In the CalPERS decision, which is actually cited in the Public Citizen's textual analysis amicus brief, this court clearly delineated between actions and claims, and it did so by citing 1933's Black Law Dictionary, which says that the concept of an action is, if not entirely, almost entirely synonymous with a suit. And so there's no way to split that hair, especially in light of the fact that, as I believe you pointed out earlier, Your Honor, Section 2672, which is the release bar, refers to complete release of any claim. So Congress knew how to distinguish between these concepts. It chose not to in the judgment bar because it was adopting res judicata.
Thank you, Mr. Giacomo.
Justice Gorsuch?
Good morning, counsel. I'd like to just return to the, I guess, your alternative argument, the same action simultaneously pending position. What do we do about the fact that your client chose not to pursue his FTCA claim on appeal? And so the judgment there would seem to be in an action, and it's final. There doesn't appear to be any simultaneously pending action under the FTCA at this point.
Yes, Your Honor. So the distinction is still the concept of actions versus claims. So even with an action that has multiple claims, the failure of one claim or the waiver of that claim doesn't doom the other claims. As we cite on page 26 of our brief, the statement from Wright and Miller, which says claim preclusion is not appropriate within a single lawsuit so long as it continues to be managed as a single action.
So we just go back to the question whether any means any judgment in an action, which seems to contemplate the possibility of multiple judgments.
Oh, no, Your Honor. Actually, the language of Section 2676 says the judgment in an action, which is the definite article, requires that there can only be a single judgment in an action. Yeah. And that judgment necessarily must deal with all the claims in the action, so you can't have the judgment in an action and there still be any action left to apply the preclusive bar to.
What about the any action by the claimant language?
Yes, Your Honor. This just goes back to the linguistic distinction between an action and any action. And I'll also point out that a number of courts before the enactment of the judgment bar had used the phrase complete bar to any action to mean res judicata. But even if that weren't the case, at the time the judgment bar was enacted, Congress understood that for jurisdictional reasons, a party could not sue the United States as a co-defendant with its employees. So the need for something like separate or subsequent.
I guess what I'm trying to get at is we have the judgment in an action under the FTCA, and that would seem to bar any other action like Bivens later. And your way around that is to say that they're simultaneously pending, but the judgment under the FTCA seems to be final in this case.
No, Your Honor. The judgment in an action is not final because that action is this case directly on appeal.
But so, you have okay. All right. Thank you, counsel.
Thank you.
Justice Kavanaugh?
Thank you. Good afternoon, Mr. Giacomo. I want to raise the point that's bothering me about what we should decide, and I don't blame you for raising the alternative argument. I understand that. You're trying to win the case, but trying to think about why we should consider it. We obviously discussed very carefully our decisions to grant certiorari on particular cases and particular issues within that case, and we don't usually decide things that weren't decided by the court below, and there are exceptions to that, and no doubt about that, but I don't think this is embedded within in the way you said, and sometimes we'll do it if it's really, really simple, and it will be helpful just to go ahead and resolve it, but I'm not sure this qualifies as really simple either, because if we get to the merits, at least not very simple in your direction, because if we get to the merits of that alternative argument, every court of appeals save one is ruled against you, and the text says any action, not any subsequent action. You have forceful arguments in response to that, but I guess I'm just back at why should we consider that issue at this time in this case, given the way it was developed in the Sixth Circuit?
Yes, Your Honor. So, as I mentioned earlier, there's no question that the Sixth Circuit didn't predicate its decision on this point, but it was raised in the Sixth Circuit. And in the Simmons case, this court actually decided the FTCA decision on a separate grounds than the one that the Sixth Circuit had used below. And so here I think the existence of the other circuit court decisions, which, as I mentioned, although they somehow agree on this same claims point, they do so in very different ways, illustrates that there's an enormous amount of confusion that this court could very simply clear up and do so consistent with its decision in Simmons and Will, which is focused on stating that the purpose of the judgment bar is to prevent duplicative litigation, as this court said in Will, multiple suits on identical.
Can I just stop you there? You said the other courts of appeals have ruled against your position on this issue in many different ways, and I don't see how that makes it easier to clear that up. That just means there are lots of routes that courts of appeals have thought that lead to the opposite result from what you're suggesting here. That would seem to make it harder, not easier, for us to just, in your words, well, I don't know if you use this phrase, but to clean it up or clear it up, as you said.
Yes, Your Honor, I do think the one thing that animates all of those decisions is why this court should weigh in, which is that all of those decisions repudiate or simply ignore the fact that Section 2676 incorporates res judicata, which has as its central premise the concept that you can't be barring claims brought together in one lawsuit.
Well, that just goes back to the any action versus any subsequent action argument of the government, which I understand your point on that. My time's up. Thank you very much.
Justice Barrett?
Counsel, I want to make sure that I understand your position on the nature of this judgment and whether it's on the merits or can be a bar. Is it your position, and I thought I heard you say this earlier, maybe it was in response to the Chief Justice, that a judgment is only functions as a bar if it's entered after trial?
Yes, Your Honor, that's one of the lines that we draw. There are three. Simply put, in this case, because the government requested and received a 12B1 dismissal, the court doesn't even need to reach that second.
Okay, but what about if it's a summary judgment? Didn't the government also in this case request summary judgment in the alternative? I thought they had said 12B1, 12B6, or summary judgment.
Yes, Your Honor, they did request it in the alternative, but the district court didn't grant that, and all through the Sixth Circuit, the government continuously said it only moved under Rule 12, and it's only been at the merit stage that they've now said it was actually a Rule 56 summary judgment decision.
Okay, so what if they had won summary judgment? In your view, then, is that a judgment that even if the United States wins can then be a bar?
I think it depends, Your Honor. I think because a court is required to assess its own jurisdiction, that a court necessarily has to decide, certainly in a situation where a party has raised these alternative avenues for relief, that...
Okay, no, just answer the question. So it's summary judgment, and the United States, then, I just don't understand how that's not then on the merits.
Yes, Your Honor, it simply depends on whether there has been actual fact-finding or not. And the reason that the on the merits portion is a little obscure is because, as I mentioned and the government agrees, the language of Section 1346B entwines merits, jurisdiction, and sovereign immunity.
Okay, let me ask you a question about this second alternative argument that you've made. Let's say that you bring a Bivens claim first, and you lose, and then you bring an FTCA claim against the United States. Can the United States then, just under regular common law preclusion, assert defensive issue preclusion against you?
No, Your Honor, I don't think that it can because, as the professor's amicus brief points out, there's a different primary right at stake. And so if simple preclusion was being applied, a Bivens claim before an FTCA claim would not have a preclusive bar.
Well, but issue preclusion just requires identity of issues, right?
Yes, of course, we're talking about claim preclusion, but if we were talking about issue...
I know, but I asked about issue.
If we were talking about issue preclusion, Your Honor, yes, there would be certain issues that could be carried over from the Bivens claim to the FTCA claim, but if you look at a case like this, the FTCA claim was decided on grounds of government immunity that wouldn't apply to a Bivens claim. So it depends on how the Bivens claim is decided if you're looking at issue preclusion.
Okay, thank you.
Mr. Giacomo, you can take a couple of minutes to wrap up.
Yes, Your Honor. Embedded in Congress's enactment of the FTCA and its judgment bar is a very simple common law doctrine that has been with litigants since the beginning of this country, which is the concept of res judicata. The primary basis for res judicata is that it only applies to separate lawsuits. This Court has said so on many occasions, and that it only applies once a judgment has been entered on the merits by a court with jurisdiction. So As I mentioned, we raised this issue of duplicative litigation in the Sixth Circuit. The government has addressed it in its brief. It's fully briefed. There's no reason that this court
C-SPAN is not federally funded. C-SPAN, more
government because both parties submitted a body of extensive.
And merits are the same issue. And this is the concept of
about issue.
If we were talking
preclusion, assert defensive issue preclusion against you?
No, Your Honor, I don't think that it can because, as the professor's amicus brief points out, there's a different primary right at stake. And so if simple preclusion was being applied, a Bivens claim before an FTCA claim would not have a preclusive bar.
Well, but issue preclusion just requires identity of issues, right?
Yes, of course, we're talking about claim preclusion, but if we were talking about issue...
I know, but I asked about issue.
If we were talking about issue preclusion, Your Honor, yes, there would be certain issues that could be carried over from the Bivens claim to the FTCA claim, but if you look at a case like this, the FTCA claim was decided on grounds of government immunity that wouldn't apply to a Bivens claim. So it depends on how the Bivens claim is decided if you're looking at issue preclusion.
Okay, thank you.
Mr. Giacomo, you can take a couple of minutes to wrap up.
Yes, Your Honor. Embedded in Congress's enactment of the FTCA and its judgment bar is a very simple common law doctrine that has been with litigants since the beginning of this country, which is the concept of res judicata. The primary basis for res judicata is that it only applies to separate lawsuits. This Court has said so on many occasions, and that it only applies once a judgment has been entered on the merits by a court with jurisdiction. So, as I mentioned, we raised this issue of duplicative litigation in the Sixth Circuit. The government has addressed it in its brief. It's fully briefed. There's no reason that this Court shouldn't honor the language that Congress enacted by addressing this claim issue. And even in the alternative, the independent ground here also justifies this Court affirming the Sixth Circuit because the government moved for and received a dismissal on the basis of jurisdiction. It should not now be allowed to come to this Court and say jurisdiction and merits are the same and merits should therefore prevail because, as Wright and Miller and the first restatement and many other places have said, anytime jurisdiction is entwined with merits, jurisdiction controls, not merits, and if it was the other way around, the Court would be able to reach beyond its actual authority granted by Congress. So for these reasons, this Court should affirm the Sixth Circuit and allow James King to continue taking his first and only bite at the apple in this lawsuit.
Thank you, counsel. Mr. Houston, 3 minutes for rebuttal.
Thank you, Mr. Chief Justice. Regarding the question presented, the judgment bar is triggered by the judgment in an action under Section 1346B. Respondent created just such an action by pleading a demand for relief alleging the elements of Section 1346B, and the district court indisputably entered judgment. The Sixth Circuit explained at Petition Appendix 1A, Note 1, why the district court's judgment is best understood as a summary judgment in favor of the government because both parties submitted a body of extensive evidentiary exhibits in support of the motion. But even if the court concluded that the judgment was best understood as a dismissal for failure to state a claim, it makes no difference because it's still the judgment in an action under Section 1346B, as Meyer explained, and this court's canonical decision in Bell v. Hood makes clear that a dismissal for failure to state a claim for relief is a decision on the merits and therefore preclusive. The surest way to know respondent's main argument on the question presented is incorrect is that it forces my friend into the extraordinary conclusion that the judgment bar is not triggered by a judgment in favor of the United States on the FTCA action. Simmons squarely foreclosed that, and the plain text refutes it. Now, regarding my friend's fallback argument, I think as the court has recognized this morning, it certainly has discretion not to consider that argument in this case, and that's the most appropriate disposition because the alternative question simply isn't cert-worthy. There's no significant disagreement about the circuits on it. The only circuit that has even come close to saying something like that argument is the Ninth, and that the basis of its reasoning was abrogated by Simmons. The court should not leave in place the Sixth Circuit's rather obvious mistaken interpretation of the judgment bar and instead decide the case in favor of respondent on an alternative ground that no other court has accepted. If the court were inclined to reach the alternative question, we think the text is unambiguous in our favor. Congress would have looked at a lawsuit like this one and said respondent has an action under Section 1346B and an action under Bivens, and he has joined them together in a single lawsuit. but there is simply no way to read the phrase complete bar to any action to actually mean that respondent is precluded only from bringing a subsequent action when that is exactly the common law rule that Congress expressly changed. In the 70 years since the judgment bar was enacted, the courts of appeals have overwhelmingly rejected this argument. And that's because, as Justice Breyer recognized, it directly conflicts with Congress's purpose. The rule that respondent advocates would permit a plaintiff to sue the United States and win, and then continue pursuing individual government employees for additional relief just because he brought his two actions together in the same lawsuit. That is exactly the result that Congress created the judgment bar to prevent, as this court explained in Gilman. For all those reasons, the judgment should be reversed. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.